back it up if you get there, but you don't need to like cut it out in the beginning, I don't think.
So you represent, and then I'll get your question, 50% of our faculty. So we sit every year and debate in faculty meetings about process. And how important it is to go through the process. And so some of us feel like, why are we, like, let's just vote. Like, we'll have an issue. Why can't we just vote on the issue? We know we have the overwhelming majority. We know it's going to pass. Let's just vote on this new initiative. But no, the process says we have to set up a committee. The committee has to meet. They have to draft up a proposal and come back and have a discussion about it. And well, we know what the outcome's going to be. So half of us are like, this is dumb. Like, it's a waste of our time. I don't want to be on the committee when we already know that we're going to vote yes. But the other half said, no, process. We have to there's a process in place to make sure there's transparency, fairness, because if we start allowing people to circumvent process for this, they're going to circumvent process for other things. And so there's always been kind of that bumping. Like, for instance, let's just say hypothetically, Shelley Santry was hired as an adjunct, right? She wasn't, but let's just say she was. We love Shelley. She's like rock star over there at the clinic. It's a lot of work, but she's an awesome professor and a pleasure to work with. So there's an opening that comes up in the clinic. We're like, hey, everybody loves Shelley. Her evals are good. Why reinvent the wheel? Let's just hire Shelley and keep it moving. No, we have to have a formal search and have a process. And that's what I mean. So he's someone that respects the process, right? And says, I think the process should be in place, but I guess my challenge is I understand that, and I know it's dangerous when you start circumventing process, but my gosh, the docket is so backed up. Some people are waiting years just to hear their cases and get redressed because of goofy stuff like this.
Some people like to go through Congress. Other people like to do these executive
orders.
emergency orders.
Beforehand, and then yes, Elizabeth.
Well, I actually just thought about it more in my head. So when you were saying that, I was just thinking, so why didn't the defendants challenge both, like the venue and the claim? But they did. They
did, but they didn't
right.
do their due diligence.
Right.
They didn't provide any evidence. They said, failure to state a claim, but they didn't provide any evidentiary basis, meaning you have to say this is why this claim is not sufficient, and it's a waste of the court's time. It's not a legitimate claim, and so they didn't. That's why the court's just like, we'll just address venue. I don't know why they didn't. That's the only disadvantage about these cases. Sometimes you can't see behind them.
That's what I was going to ask about, because it mentions that they didn't request an evidentiary hearing, and it says they didn't file any affidavits or anything. So if they had, is it possible that they maybe could have had it dismissed?
It could have been dismissed at this level. So I don't know why. Yes.
How could
you
they
moved? Yeah, I just realized why. I was like, wait, what are you doing up there? But hi, yes.
How could they dismiss it, though, if they don't have the authority to because it's in the wrong venue?
Right, and that's a good point, too. So she was saying, and she remembered the distinction. How could they dismiss the case if it's in the wrong venue? Because remember, you can only dismiss with 1406, but not under 1404. So their only option was to transfer to the proper venue. But they could have got the case dismissed under that failure to state a claim if they had pursued it, and they should have. Better pursued it. All right. So where are we? So we know instead of dismissing the case, the court elects to transfer, as I stated. A substantial part of the omissions and events giving rise to the plaintiff's claims occurred in the Southern District of Mississippi. That was the court's assessment. Reeves driving a plaintiff to the Southern District and not waking him up in Jackson. Colonial Trailways operation, their bus and Greyhound sell ticket. Everything happened in Mississippi. So under 1406, again, where venue is in the wrong division, the court has the option under 1406 to dismiss or transfer the case. In terms of 1391B3, right? 1391B3, the reason the plaintiff could not use that particular section is because venue can be established under 1391B2. So if one of those first two options are available, you cannot use 1391B3. So the whole important takeaway from this case is just showing you how, what it looks like when someone is challenging venue as being improper, how you go through the steps and seeing whether 1391B1 or B2 is applicable, and kind of what the court's rationale is in deciding these decisions. And so it's just like for the rest of the semester, what we'll be doing is you're going to have a rule, and the case is just showing you what the rule looks like in practice. Okay, so it's just providing you an example. So before I transition into the form or the doctrine of non-convenience, sorry. Any questions about 1391? Because we're not going to come back here for a minute. All right. So the judicial doctrine of forum non-convenience. So it's essentially a Latin phrase, as you can tell, that means, surprisingly, the forum is not convenient, right? I would have got that right on the LSAT. That was pretty easy. So what's the difference then between this doctrine of forum non-convenience and section 14A, right? Because obviously they kind of look like the same thing. So section 1404A does not permit dismissal of the case. It only permits transfer of the case from a proper forum to a more convenient forum. So again, the difference between the doctrine of forum non-convenience and section 1404A is that section 1404A does not permit dismissal of the case. So section 1404A does not permit dismissal of the case. It permits only a transfer of the case from a proper forum to a more convenient forum. So again, 1404A does not permit dismissal of the case. It only permits transfer of the case from a proper forum to a more convenient forum. On the other hand, the doctrine of forum non-convenience, the court may dismiss the action because the forum is inconvenient. Right? That's pretty big. Do we like this doctrine? Just because it's inconvenient, don't dismiss my case. Yeah, so again, under the form of doctrine of forum non-convenience, a court may dismiss an action because the forum is not convenient. The catch is that a greater showing of inconvenience is required for a forum non-convenience dismissal than for a convenience transfer under section 1404A. So again, the standard of proof you have to provide of showing the level of inconvenience is much higher if you're going to use the judicial doctrine of forum non-convenience to dismiss a case, as opposed to under 1404A, if you're just trying to transfer for more convenience, you don't have to have it as high as the standard. It doesn't have to be as egregious. So if you feel like it's blatantly obvious that this case should be dismissed, like again, I used a plain example, everything is obviously in Florida, the witnesses, the plane wreckage, you would do the judicial forum non-convenience. If it's not that cut and dry, it's a Burger King situation between Michigan and Florida, then you might want to try section 1404, right, to transfer the case. All right, so some examples of forum non-convenience. In this sense, why would the court dismiss rather than transfer the claim? The court dismisses because it cannot transfer, right? Because a more appropriate court is in a different judicial system. So that's one of the reasons you would use the doctrine of forum non-convenience. It's because the appropriate court that it should be in is a different judicial system. So say they realized the court was filed in federal court, but really the case should have been filed in state court. Well, because you can't transfer between different judicial systems, the court has no choice but to just dismiss the case, right? So that's one of the reasons. So an example would be a case is filed in a proper state court in Alabama. The state court of Alabama has personal jurisdiction, subject matter jurisdiction, and venue is proper, right? But the Alabama court, but it makes more sense, for the litigation to be heard in Florida. So even though, again, in Alabama state court, personal jurisdiction is proper, subject matter jurisdiction is proper, venue is proper, it makes more sense for the litigation to be held in Florida, which is what we'll discuss in the Piper case. The Alabama court cannot transfer to Florida, the Alabama state court, because they're a different judicial system, right? So if the showing is strong enough, the Alabama state court will dismiss the case under this doctrine of forum non-convenience, all right, and permit the litigation in Florida. They will dismiss the case. If the case had been filed in a federal court in Alabama, then would you need to use the forum non-convenience? And the answer is no. Why? Because if they had filed the case in the federal court of Alabama, that's fine. You just need to transfer it to the federal court in Florida. It's still within the same judicial system, okay? Does anybody not understand that? All right, so let's see what this looks like in practice. So the Piper case, Mr. Cannon, Attorney Cannon, if you can give us the facts. Well, actually, tell me who the plaintiff is first in the Piper case.
It's the, oh, I love this word and I'm gonna botch the pronunciation. Is it the testatrix of the estate of the deceased?
Yeah, can you put that in layman's terms?
Like the person that's administering the estate?
Yes, excellent. You pronounced it correctly.
Okay,
You looked it up.
cool.
All right, yeah. So it's not the heirs, right? It's not the heirs and the next of kin of the Scottish residents who died in the plane crash. It's actually because none of them are named Reno. The plaintiff, as he stated, is the administrator, right, of the Scottish decedent's estate. So basically, the lawyer's administrative assistant. She's the plaintiff, and so she's basically filing this suit on behalf of the estate. That's how estate suits work. We know that the decedents in this case were Scottish. Who's the defendant, Attorney Cannon?
The defendants are the manufacturer of the plane and the manufacturer of the propellers and the Scottish, I think the Scottish taxi service that owned and maintained the plane is included. I think.
Yes. Okay, so we have Piper Aircraft, right, is one of our defendants who made the plane in Pennsylvania. And just the second one, not the taxi, and Hartzell, who made the propellers in Ohio. Okay, so those are our defendants. So since forum nonconvenience is all about assessing whether there is a more convenient forum, let's break the facts down and associate them with the specific location and space. Okay, so what do the facts state occurred in Ohio, Attorney Cole? What occurred in Ohio?
Just that they manufactured the propellers.
Excellent. So all we know is that defendant one, which is Hartzell, manufactured the propellers in Ohio. So that's the only thing that happened in Ohio. What about Pennsylvania, Attorney Cole?
That the engine was manufactured in Pennsylvania.
Okay, you see how this is getting convoluted already. So we know propeller created or manufactured in Ohio. The actual plane was manufactured by Piper in Pennsylvania. What happened in Scotland? The obvious, the crash, right? It was operated by a local company. The problem is there were no eyewitnesses, but all the decedents, heirs, and next of kin are Scottish, right? And the plane was subject to Scottish air traffic control when it crashed, and we have a Scottish pilot. This is really not good. All right, so Attorney Cannon, where was the airplane registered, maintained, and owned?
Okay, yeah, so that was for McDonald Company. And it
What
was in
country?
Scotland.
Sure.
Oh,
United Kingdom.
cool.
UK, thank
Oh,
you.
sorry, right.
That's all right, Attorney Cole.
Yeah.
So,
Which is
we
in
know
the UK.
that the plane was registered, maintained, and owned in the UK, airplanes, and then what else was in England? The obvious, the wreckage, right, was in a hangar in Farnborough, England. The British Department of Trade investigated the crash, looking to see whether or not there was mechanical failure with respect to the airplane, engine, or the propeller. And they also looked to see whether or not there was pilot error, right? Which probably was the cause of the crash. There was no evidence of defective equipment. So there are a lot of different locations that are associated with this plane crash, which could be kind of a litigation nightmare. So we know the plaintiff finally initially filed a suit in California State Court, right? And then where did it go from there and how? What did the defendant do? Attorney Cannon.
Yeah. I think it was, I'm trying to remember who was first. I think Piper moved to transfer it to the Middle District of Pennsylvania, where they have,
Removed it to which federal court?
the
Kind of a messy case.
third, no. California, sorry. No.
Honora, so Honora's like horrible ventriloquist. So, like, I've seen people help their colleagues, which I'm totally fine with, but they're like real smooth with it. She goes, California. That's not how you do it.
That's
all
right, I have it right here too, I don't know why I'm, yeah. Okay, yeah, it's the Federal District Court in California invoking diversity jurisdiction.
Okay, so yes, so essentially, it's plaintiff says, I want this case in California State Court. Defendant's like, no, I'll get eaten alive. I want this in federal court based on diversity jurisdiction, meaning plaintiff and defendants are residents of different states, and the amount in controversy is over $75,000. We'll cover that when we do subject matter jurisdiction. So how then does he get from California to Pennsylvania? Well, Piper moved to transfer the case to Pennsylvania under Section 1404A for convenience. Then Hartzell moved to dismiss the case for lack of personal jurisdiction in California and asked for the transfer to Pennsylvania as well. So personal jurisdiction was proper in Pennsylvania in this case because that's where Piper manufactured the plane, and Piper did business in Pennsylvania. So personal jurisdiction was proper over Hartzell there too, unlike California, under the minimum context test because again, Hartzell did business there as well. So then what happens when we get to federal court in Pennsylvania? What did Hartzell and Piper do, Attorney Cole? When we get to the federal court in Pennsylvania, what motion did they file?
Form
Yes. No, you said it right. Yeah, so Hartzell and Piper filed a motion to dismiss the case under forum nonconvenience. And, I want to note that the litigation strategy of our defendants are basically first they remove the case from state court to federal court in California. Then once that case is in federal court in California, they argue that it should be transferred to Pennsylvania under Section 1404A because it's a more convenient forum. Then their third litigation strategy, once they get the case transferred to a federal court in Pennsylvania, was then to file a motion to have the case dismissed based on the form of nonconvenience. They are litigation geniuses, okay? They have worked this system strategically, and that's what you will do to get this case to where they want it. And so, Attorney Cannon, how does the district court rule on the defendant's forum nonconvenience motion?
So the district court granted the motions and saying that it was, I'm pretty sure it was that it was like burdensome to the defendants to litigate there, so they dismissed it.
Granted the motion, dismissed the case, okay? So plaintiff's not happy about this, so they appealed to the Third Circuit Court of Appeals, and the Third Circuit Court of Appeals disagrees with the district court's decision. Third Circuit believes that the forum nonconvenience dismissal is not appropriate when the law of the alternative forum is less favorable to the plaintiff. So I mentioned earlier in class that there's a whole law school class you can take on choice of law. So just because I file a case in the federal court of Kentucky, based on the facts and the circumstances of the case, I still may have to, the federal court in Kentucky may still have to apply Alabama law or Ohio law to that case, even though it's being litigated here. And so that's what the court is saying. This is one of those choice of law situations. And so they believe that you should not be able to use forum nonconvenience if, again, the law of the alternative forum is less favorable to the plaintiff, and it was in this case. So the Third Circuit reversed the case, right? The district court's opinion. So the issue in this case is whether this lawsuit, after all those gymnastics, should be dismissed under this doctrine of forum nonconvenience. So we know the Third Circuit reverses the district court's decision, but how does the Supreme Court address the Third Circuit's reasoning that one cannot grant a forum nonconvenience motion where the alternative law is less favorable? I think it's on page 189. Let's see if it's right. Yes, on 189. So how does the court, again, address that situation?
They pretty much just say just because another forum has stricter laws, it doesn't matter. You can't just dismiss it or reject the motion.
Excellent. Yes, the court tells us that making a forum nonconvenience determination requires flexibility, right? They said there's not just bright line rule about which laws are more favorable to the plaintiff or the defendant. Instead, we should consider the private and public factors, right? which do grant us some level of flexibility. So we love the court here because finally, prior to this case, it was completely left up to the judge's discretionary opinion on whether or not they're going to grant a motion to use dismissal based on the doctrine of forum nonconvenience. Now they've given us criteria to look at. They've given us a framework, and that's these public and private factors. So for exam purposes and practice purposes, we need to know these factors because that's how you're going to make an argument whether or not a forum nonconvenience motion should be granted. Okay, it's based on these public and private factors. With respect to that, the court is, I guess the question is the court saying that an unfavorable change of law should never be a factor? Well, they're not explicitly saying that on the top of page 190, but they're saying it might be a relevant factor, right? Meaning if the court you're transferring it to is going to have an unfavorable outcome because of a difference in the law there. So the question is, does this case fall into that category, meaning where the remedy is so inadequate that the plaintiffs would have, no redress whatsoever? And the court says no. The court says although the plaintiff may not be able to get strict liability in Scotland, it may get lower damages, they will not be deprived of a total remedy. Well, that kind of bothers me because I'm like, even though you're telling me I can still get some remedy, I don't want to be disadvantaged. If I can get $500,000 versus $100,000, that matters to me. So I think the court, I don't like the level of insensitivity there because they're saying, it's not like they're going to get no remedy. They'll still get some remedy, but the strict liability remedy statutes in Scotland are going to give them less money. I don't like that. Attorney Cole.
Do you think that it would have been different had they had more evidence as to the actual manufacturing process? Because they said that they didn't think that there was any error, and yet they were still trying to claim strict liability.
Yeah, because then you get it here in the States in a more favorable form, absolutely. But I think it matters, and I hate that the court's kind of nonchalant about it. They can still get some remedy. And so, in making this forum nonconvenience determination, the courts will consider a number of factors. The Supreme Court notes these factors in footnote 6 on page 188, footnote 6, page 188. So the private factors are that you consider the ease of access to available sources of proof. You consider the availability of a compulsory process for attendance for unwilling witnesses, meaning can they compel a unwilling witness to come anyway? The cost of obtaining attendance of willing witnesses. Am I going to have to fly them from, was one of the witnesses somewhere in France, a resident of France, so they consider that. Relative advantages and obstacles to a fair trial. The existence of an alternative forum that will provide adequate relief. And so they also talk about private interest factors that should be considered, right? And again, these are all in your text, so I'm not going to go through them very slowly. I told you where they're located. They look at administrative difficulties for courts, meaning how backed up are the dockets in Scotland, right? They look at the interests of the local community and having a trial touching on the community's interests. Is there something dealing with Comfy Cow, where there are people in that community that died that were on that plane? The burdens of jury duty on a community which may have little or no relationship to the litigation, and the interest in avoiding having courts interpret other states' laws or foreign law, which is a big one. So if you represent the estate where Reno is, what are your arguments under these private interest factors, right? And I know we're almost out of time. I was trying to finish, but I'm not, but I hate not to come back to it. So if you represent the estate, again, where Reno is, your arguments are going to say, your arguments with respect to, if you're using the public interest factors, you're going to say the records concerning the design, manufacture, and testing of the propeller in plane or in the U.S. is one argument you're going to make, using, again, the private factors. You also would say that the plaintiff, and I'll email this to you since I'm going fast, would have more access to sources of proof relevant to the showing of strict liability and negligence if the trial is in the U.S. On the other hand, if you represent the defendant here, meaning the plane and propeller manufacturers, the argument under the private interest factor is going to be like, hey, look, the crash occurred in Scotland, so the evidence and witnesses are located there. It'd be more expensive for Scottish witnesses to have to travel all the way to the U.S. to testify. So we know the Supreme Court ends up concluding with respect to the private interest factors that the court notes that the forum nonconvenience determination is within the trial court's sole discretion. It may be reversed only for a clear abuse of discretion, right? The court also says that although private interest points in both directions, the district court was not unreasonable, right, in concluding that fewer evidentiary problems would be posed if the trial were held in Scotland, as again, a large part of the evidence is located in Great Britain. Additionally, the court mentions that there may be serious issues with forcing a third party in Britain, meaning Air Navigation and McDonnell, to come and be a part of that case. And so, if the defendants can prove, the court said that there's no design defect, but that the pilots or the charter company's negligence led to the crash, then the defendants would have zero liability. And then last but not least, the court talks about the public interest factors. It essentially says that Scotland has a very strong interest in the litigation. The accident occurred there, which makes sense. The decedents are Scottish, and apart from Piper and Hartzell, all potential plaintiffs are decedents. All potential plaintiffs and defendants are either Scottish or English. So they said there is a local interest, which I agree with, in having localized suits decided at home. And then lastly, the plaintiff argues that there's an interest in protecting American citizens from American manufacturers producing defective products, but the court says that the incremental deterrence and holding in their favor basically is insignificant. So what's important, I will cover this again in our next class, meaning I'll back up as I always do and go back over these main points. And I'll email them to you so you can, like my points I was making, so you can think about it and then tell me what questions you have. But what's important, the takeaway from this case is that if you're trying to determine whether or not to use a form of nonconvenience, you evaluate the public and private factors that are in the footnote in the text. That's the black letter law to take away from this case. All right, so I will email you all shortly, and have a good day. Thanks for letting me keep you for extra 3 minutes. Are you serious? Yes. Thank you. You know what? Why didn't more people say that?
I was about to
Let's
go.
back up.
I haven't looked at the clock in a while, so.
I was thinking 10.
That was right.
Thank you.
But my mind is already gone. Can you
I
write?
know. I saw people like packing their stuff up, and I was like, well. Okay. So let's back up. So this is good. So let's back it up slowly. No, I'm not emailing now. I'm slow down. All right. So let's back up. So yes. So if you represent the estate administrator here, Reno. Yes. What are your arguments under the private interest factors? And what I was saying is that you would say the records concerning the design, manufacture, and testing of the propeller and plane are in the U.S., which I think is important argument to make, right? And then second, the plaintiff would have more access to sources of proof relevant to showing strict liability and negligence if the trial is in the U.S. So if I were representing the estate, the plaintiff, those are the arguments I would make with respect to the private interest factors. Again, I would say the records concerning the design, manufacture, and testing of the propeller and plane are in the U.S., which possibly could have caused a crash, right? And then as you have more access, the plaintiff would have more access to resources and sources of proof relevant to showing strict liability and negligence if the trial is in the U.S. But if I'm the defendant and I don't want the trial here in the U.S., the arguments under the private interest factors would be, look, I understand the parts were manufactured and designed in the U.S., but the crash happened in Scotland, right? So the evidence and witnesses are located there, which makes complete sense. And it would be a lot more expensive for all those witnesses to have to travel from Scotland to the U.S. So again, those are arguments that I would make if I were representing the defendant under these private interest factors. And I think those make sense. So what does the Supreme Court end up concluding about, again, the private interest factors? First, the court notes that in determining the form of nonconvenience is within the trial court's sole discretion, as I mentioned earlier, and may only be reversed for a clear abuse of discretion. The court says also that although the private interest points in both directions, that the district court did not act unreasonably, okay, in concluding that fewer evidentiary problems would be posed if the trial were held in Scotland, which I agree, because again, a large part of the evidence is located in Great Britain. So you're already in Europe, you're already on that continent. You're going to have people come all the way to the U.S. I think it's important too when the court mentions that there might be serious issues. They say with impleading a third-party defendants. So we won't cover impleading here because it's CIPRO 1, but essentially the way that it works is, and you're not going to be tested on it, CIPRO 2, I'm just explaining it. If I'm the plaintiff, I file a case against the defendant, and say the defendant has a business partner, and he's like, well, I'm guilty, he's guilty, he's jointly liable as well. And so the defendant can file a motion to implead to force his business partner to be a part of the suit as well. And so that's what that means. So they're saying here that there might be serious issues trying to implead any potential third parties that might share joint liability if they're all located in Britain. It's very complicated when you're trying to force a defendant from Britain who was not originally named in the lawsuit to come over here and defend themselves. So that's what that means. And then the court said if the defendants can prove that there's no design defect, but the pilot's or the charter company's negligence led to the crash, then the defendants again would have zero liability. And then last but not least was the public interest factors that I was racing through. And the court concluded that based on a choice of law analysis, if the case were tried in Pennsylvania, Pennsylvania law would apply to Piper, and Scottish law would apply to Hartzell. Again, that's that class that you would take to tell you why that is. So having a trial involving, they said, two sets of law, so Pennsylvania state law and Scottish law, they thought, which I agree would be too confusing to a jury. And the court lacked familiarity with the Scottish law as well. And so Supreme Court says consideration of these factors by the district court is indeed appropriate. Imagine how difficult it would be for a federal judge trying to interpret Scottish law and then apply it when they weren't trained in that particular area. So in terms of why the Supreme Court agrees with the district court's application of the public interest factors, again, they were just basically talking about the strong interest that Scotland has in litigating the case there since the accident occurred there. It involves some of their residents in terms of eyewitnesses, and so they just really focused on the fact that there was they felt like Scotland had a local interest in having localized suits decided at home instead of here in the U.S. And so the plaintiff argues that there is an interest in protecting American citizens from American manufacturers producing these defective products. But the court says, again, not significant. And so the takeaway from the Piper case is we know the Supreme Court overturns the appeals court's decision and held that the district court did not abuse its discretion in granting that forum nonconvenience to dismiss. And more important, in making a forum nonconvenience determination, courts will assess the public and private interest factors noted in footnote 6. Okay, that's the black letter law to take away. So again, in making a forum nonconvenience determination, the court will assess the public and private interest factors contained in footnote 6. The Piper case is important for you to read as well because it's designed to highlight the fact that venue can be challenged essentially in three main ways in federal court. So you can challenge it via 1404A, 1406A, and forum nonconvenience doctrine. So there's three ways you can challenge venue. Again, and that's where the plaintiff initially filed the suit. Three ways. Now, when you hear all this, aren't you kind of surprised? Like before I came to law school, I didn't realize. I just thought you file your case in a court, and the judge listens. You might have a jury. Like I didn't realize all of these shifts could happen in turns, and I'll give you litigate somewhere else, and that I had all these considerations, and that the state had to have personal jurisdiction over the person that I'm filing a lawsuit against. Like, I didn't realize it was quite this complicated. Is anybody kind of surprised at all the levels, or not really, because it's law?
Not really, 'cause it is so often. I didn't know it was be extensive. I knew it would be extensive, but I didn't.
Just to file a case, like, my God, it's a lot. I mean, I understand why the rules are in place for fairness purposes, but it just seems like, and there's so much more. This is just Cipro 1. There's so many more twists and turns, but, okay, now we're actually done. And does anyone have any questions about the takeaway from Piper? Yes. Yeah, section 1404A.
Ashley, meet us in the corner.
Challenge case. 1406A.
We don't meet tomorrow.
And then, form
Great.
No.
All right, have a great day.
I think they forgot the espresso shots in here. I just like shots it.
Maybe you're like immune.
No, I'm not.
Because you drink so much of it.
This usually lasts me all day, and I just was like, where is it?
What do you think about this case?